uniform now and share logos and all the fun stuff. So check out our website July 1st, or I guess after July, and then you'll be able to see the new color updates that we have. But also, our address has changed. We're on 420 South Temple. It's a new address, so I don't have it memorized just yet. But we hope to welcome you all there too. So know that things are changing. We will be sending updates for new material, brochures, and all that fun stuff as things get approved. So just look out in those Swavo emails, and we will be sending it out in that forum. But otherwise, we're so excited that you're all here today. Just a quick other announcements that we have. We have our August Victim Assistance Academy, and it'll be the last 2 weeks of August. So if you have a new advocate or you'd like to join us in this forum, please feel free to sign up. And then otherwise, just as a reminder, our St. George Swavo is not going to be on a Thursday. It's going to be Wednesday, September 9th, but same place, same place. So all of the typical stuff at the Abbey Inn, Best Western will be there. But just, hotel conference dates and stuff. So just have that in mind. The date has changed. And then when you close your Zoom, there is a quick survey. We'd love to know what topics you'd like us to bring in to Swavo, but also just hearing any feedback. And then the save the date will also be there for September 9th. But if you have any questions about any of the updates, please reach out to Vicki and I. We'd be happy to support you. But otherwise, I won't take more time from Brandon. We're so excited that he's here with us in his new role as well. Brandon Merrill is a prosecutor at the Salt Lake District Attorney's Office. And we welcome you in this space, Brandon. Thank you so much for being here with us.
Yes, of course. Thank you. All right. Well, let's see here. I'm not sure how there we go. Oh, I'm not, sorry, my laptop is asking me to give permission for Zoom to look at things. So give me just 1 second. This is okay. Let's see here.
And those who don't know Brandon, he was the one that founded the Homicide Survivors here in Utah as well. An incredible resource and unique resource that we have as well here in the state of Utah. So just want to shout that out as well.
Yes, thank you. Okay. Can you guys see my screen? Is it
Yeah.
okay? It was trying to tell me it was going to restart the computer, and I was not wanting to do that. So, yeah, so as Beatrice said, my name is Brandon Merrill. I am a prosecutor at the Salt Lake District Attorney's Office. Before that, I just joined last year. And before this, though, I ran Utah Homicide Survivors, which is a nonprofit legal services group for families of murder victims, mostly dealing on the civil side, but also some victims' rights and different things like that. Within that realm, I did that from 2018 until last year, 2026. And before that, I was with another group in Arizona that did similar things, but for uh, all victims of either domestic violence or homicide. And then I graduated from Vermont Law School in December of 2015 and was basically before that, I grew up in Utah and Arizona mostly. So, um, all right. So I was asked to talk as much as I can about plea deals, sentencing, and victim impact statements today. So I'm gonna need participation in this, and so because I want to answer questions. So if questions pop up, either unmute or put it in the chat, and I'll do what I can to answer them right away. But Um, for the justice process, there are three types of pleas that are the most used. There's two others that I'm not going to get into because they're very technical and we don't need to really go over them. But for the most part, there's a guilty plea, a not guilty plea, and a no contest. And guilty means you are admitting to the crime that is charged. Not guilty, you are not admitting to anything, and you are able to continue saying that. And no contest means that you're saying you're not guilty, but you're admitting that the state has enough evidence to prove that you are guilty. Um, eh, don't ask me why that sounds better for some people. They just don't want to admit that they did wrong, and so there's some people are more comfortable with no contest than guilty, even though it is still counts as a guilty for any type of record. But as far as the criminal justice process goes, I'm sure all of you know this as victim advocates, but uh, for the court processes, there's an initial appearance first. And there's two ways to have that initial appearance. And that is either going to be through a summons, which is sent either served or sent in the mail, telling somebody that they need to appear before the judge at this date and time, or that there is a warrant or they are arrested and the warrant is still issued upon that. And so then they have their initial appearance while they are incarcerated um, at the jail or potentially prison if they were on parole and they were sent back to the prison. And at that initial appearance, they will enter into an initial plea of that guilty, not or not guilty, and the uh, judge at that point will then set bail if it's appropriate, or tell somebody that they're being held without bail if it's appropriate. But it is not out of the ordinary. And I think that's a big thing that I get from victims of all kinds now. At the initial appearance, they're very upset that they say not guilty. And that is almost automatic. And that is because the initial appearance teams for both the prosecutor's office and the DA's office, or the legal defender's office, are not the attorneys that are going to be taking the case after that initial appearance. And so if they qualify for a public defender, they're just going to enter a not guilty and then have them meet with their actual assigned attorney in front of their actual assigned judge. And so a lot of people don't realize that and they get upset because, oh, he admitted to it, or oh, it's all on camera. It it is just it's almost an automatic thing to say not guilty. And that doesn't necessarily mean anything right now. It's just mostly because they need to meet with their attorney, see what their options are, because there are different things. Um, After the initial appearance, there's what's called a scheduling conference. Scheduling conference is pretty much exactly that. We are going to be scheduling either other hearings or additional time to review evidence. Sometimes it is the first time that a defense attorney is seeing that case, and so they don't have all of the evidence that we have provided yet because of how long it takes to get things downloaded and uploaded to their system. And so they will set it out. Most judges allow for 3 to 4 scheduling conferences at the most. And those again are depending on if they're incarcerated or not, 2 to 6 weeks. And then uh, at that point, that is usually when the first plea offer will come into effect. And we'll go more into all of this. But the first plea offer from the prosecution will come at that point, and they can choose to accept it or reject it. If they reject it, then it is set for what's called a preliminary hearing. And at a preliminary hearing, the state's burden is to show probable cause that we have the right date, the right jurisdiction, the right person, and the right crime. And if you need a percentage wise, it's not very high. It's like 25 to 30% that we have to show that they probably did it. It's not very high burden, and everything that is a little more nuanced is looked at in the light most favorable to the state at that preliminary hearing. And so sometimes, depending on the prosecutors, because every prosecutor is going to be different and every county is going to be different. But for me, in my personal experience with my caseload, when I make that first plea offer, if they reject it, and set for a preliminary hearing, or I should say maybe they don't reject it, but they don't accept it and they decide to set for a preliminary hearing, then I take that offer off the table. My next offer will not be as good. So my first offer is my best offer for this defendant. It depends on depending on the crime and different things like that, and the level, but for the most part, it is my best offer. And if then I have to proceed to that preliminary hearing where I have to do a lot more prep work. I have to get victims in. I have to get them served. I have to get police officers in. I have to go over evidence. I have to prepare what is a mini hearing or a mini, I mean, it's not a trial really at all, but at least a hearing where I have to prep multiple witnesses and things like that. Then I am not going to have as good of an offer the next time. Um, so but that preliminary hearing, depending on the level of crime, could take anywhere from 10 minutes to an hour or more. It really just depends, but we have to show each element at least has been met at that lower threshold standard for each crime charged. So if somebody has 15 charges, then I have to go through and make sure I have each one that is talked about. All 15 are talked about. If somebody's got one, then it's a lot easier. So that would take, 10-ish minutes. And depending on what we need. Now, uh, victims do not always have to appear at these hearings. Many of them are very nervous about the court system, understandably, and so they will. Um, there are options to have them have their statement or testimony heard without them actually appearing, and that is from what we, in at least the prosecutors and the court world, call an 1102 statement. So that is for those that are in police departments. You've seen these, I'm sure, if you've read the police reports, but they have witness statements that have a big warning at the top, basically saying what this witness statement is, and by providing it, your appearance could be waived at court, but it still could be required, but that it is that any falsehood could, bear or put you under the penalty of perjury and things like that. And so, and then they have to sign and date the bottom as well. And so, those types of witness statements are what we are needing in order to waive an appearance of a victim in a case like this. But it also would depend on what the 1102 statement says. If it doesn't have or meet all of the elements that we need in order to charge that crime, then we may still bring in the victim, or we would ask for an updated witness statement. The Again, it really just depends on the crime and what other evidence we have on whether we would bring them in, because we still have to have at least one live witness in every preliminary hearing. So if the officer is unavailable, or if we don't have anybody else that can come in, then that's when we would try to bring the victim in. And sometimes there could be other evidentiary issues where we need the victim to come in and testify as well. And so it really is just up to the prosecutor on how they want to handle that. There's not a set thing. It is not mandatory to use 1102s when they're available, because we have to look at the case as a whole and where the weaknesses could potentially be. After the preliminary hearing, we will set, or we will usually give out another plea offer again. Usually that is not as good as the next one, but for some defendants and for some defense attorneys, that preliminary hearing is necessary in order to interview people that they otherwise would not be able to interview. Often it is an excuse to try to interview or find out information from the victim themselves, or other lay witnesses. And so they don't necessarily get that opportunity otherwise, or from the police, because there could be issues with how things were done, and they don't know that until they start asking those questions. So it is still their right, but if I have to, for me again, if I have to go through a preliminary hearing, my next offer is not as good. And so, but we will still present another offer. Depending on what is found out during the preliminary hearing, um, it it could reopen, or it could become better because depending on how the evidence comes out or how things happen, as many of you know, a lot of victims will try to recant their testimony or change it. And even if it goes against what they wrote down, um, we have to balance that. And I'll talk a little bit more about that later. But um, there's those other things. So that we have to consider. And then there's other evidentiary hearings, especially in homicides or um, fights or things like that. They will have often like a justification hearing, or there's motions to quash, or there's things where they're trying to suppress certain evidentiary things because they feel like it is a violation of either state law or constitutional rights. After those, there's usually another offer that could be presented, maybe not always, especially if it is uh, if it goes in the prosecutor's favor, where they are able to bring in everything that they're wanting and nothing is being kept out, the offer may not change. But if certain things do change, then we definitely want to look at that. And then the trial. At that point, when a final pretrial conference happens, after it is set for trial, the offers are pretty much closed. The only time I have ever not gone through with the trial after the final pretrial conference is when they just straight plead to everything that they're charged with. And so that's not really a plea offer because we can't really prevent that. Um, the only thing that we have to agree to within the types of pleas is a no contest. We have to agree to a no contest. They can't just plead no contest. So if they want to plead guilty, then there's nothing that we can do to stop somebody from pleading guilty. Um, so it, I believe it or not, and there's other things that are going to happen with that, but um, I have had people upset that a trial didn't happen because a defendant pled guilty. Um, it is, uh, but again, it's nothing that we can do to prevent that. Um, okay, so, and I should have moved these dots around, but and at the time of an incident to the when the charges are filed and then the initial appearance can vary. So part of it depends on how soon the police officer submits their case to the prosecutors to review. If I can tell you right now, I just got a case that happened 3 years ago, and they just submitted the charges. I don't know how it happens or why it happens, but sometimes it does. Um, and so it could depend because sometimes it could be the victim didn't want to move forward and now they do. And so then they're submitted. It could be that they were waiting for pieces of evidence, or it could be that they forgot, or they were transferred, or they went to a different department and a different detective was going through old caseloads and saw that it wasn't submitted and submitted it anyway. So um, that initial appearance could take place really within a week of the incident up to a very long time. Um, um, but then after that initial appearance to the preliminary hearing, that's usually, I mean, most things for the preliminary hearings are going to be about 6 months. Some cases are going to be longer, depending on how much evidence and what still needs to be processed, especially in things like murder or could potentially be like sex abuse or rape, depending on what evidence needs to be tested or phones needing to be searched or broken into or things like that. And then from preliminary hearing to the trial could take anywhere from another 6 months to multiple years, as many of you are aware of, I'm sure. Those cases, especially things like homicides or sex abuse, can take a very long time, and part of it just depends on whether they're in custody or out of custody and the level of offense that they have. So, how the court word uses it, and I should have put this in here, but a misdemeanor A that is currently incarcerated has first priority for a trial in any judge's courtroom. And that is because their maximum punishment is 1 year in jail. And so if it takes longer than a year to get to the trial, then they're then their rights to speedy trial usually necessarily are violated due to that. And that's because they are in there longer than what the maximum punishment would entail. And so those usually have the first priority. Then it goes in order of incarceration and date of the crime occurrence, not when it is filed. So sex abuse cases that are late files or rapes that are late files often will have priority over other cases that are older in the court system, but not older in time. And so that's another one you have to look at. And then it is in custody, um, depending on the level of crime and different things like that. But for the most part, it is the date of occurrence. And then out of custody cases are in that third tier, if you will. Most misdemeanor A cases are not being held in custody for that long of a period of time. And so it is very rare to have one of those bump a felony, and bump, I mean push it back or postpone the next trial. So if you would imagine that you have a simple retail theft, that would be a misdemeanor A level because they've had priors, they're incarcerated, and there is um, a domestic violence case with severe bodily injury. That would be a felony 3. That retail theft would take priority because they're incarcerated, and then it would postpone that felony 3 domestic violence case. And so it is very frustrating because it seems like, yes, that lesser crime is being treated quicker, and that is true. But that's just something that the courts have to consider. And so postponing that, unfortunately, is common. But potentially other things could happen to make that case the priority. And so it really just depends on the prosecutor or the team or the charges that are going on. Because there can be serious crimes that are misdemeanor A's that we don't want somebody out in the community for, even if their maximum punishment is only up to that 1 year level. Um, the things that we have to look at on whether we bring it all the way to trial is the strength of our evidence. Like I said, there could be missing pieces. There could be no physical evidence, especially in sex abuse cases that are delayed or rape cases that are delayed where they never went and got SANE exams or other things like that. While testimonial evidence is evidence, and they would call it circumstantial evidence, um, many juries want something physical. They want to have or see something. And we just have to be able to consider that on whether we bring something to trial or not. Most of those cases are brought to trial regardless, but there's other types of cases where there's still no physical actual evidence. And we have to look at the elements of the offense and see whether our evidence actually fits all pieces of that crime or where we are weakest. We look at the defendant's criminal history. If this is their first crime that they are being charged with, the likelihood that they are going to jail or prison is pretty much zero, unless it is a mandatory jail sentence. Um, and in more serious cases like sex abuse, rape, murder, yes, those ones are going to go to jail or prison. But in most first-time offenders for domestic violence or potentially other types of crimes, the likelihood that they are going to jail or prison is very, very low. And that is due to a pre-sentence investigation or even not, depending on the level of offense. And we'll talk a little bit about that. Also, we have to look at the victim safety, community impact, and the trial risks that we could run. I will give you an example. I had a domestic violence case that I took to trial, and part of the elements of an injury or the domestic violence charge was that it caused pain to the victim. And this perpetrator had bit the victim's finger so much that it ripped her fingernail and parts of her skin off, and it was very deep, serious gashes. She had to get it stitched. But on the stand, I asked her, "Did it hurt?" And she was trying to be tough and said, "No, it didn't hurt." And then the jury found the defendant not guilty because the victim stated that it did not hurt her when he bit through her finger, because that was one of the elements that it caused pain. And so, unfortunately, we just have to know that we never know what a jury is going to do. Um, and we just have to be able to know that a not guilty is very possible. Um, Obviously, trauma-informed prosecution is something that is being pushed all over the state, but we do trainings every week, different types of trainings for different types of things. But for us, understanding victim behavior, um, delayed reporting, recanting, and then courtroom prep, we understand that delayed reporting is common, but we have to show and get the jurors to understand how to overcome that delayed reporting. Recantation is very common, especially in domestic violence cases. We have to balance whether to force the victim on the stand and impeach them. And impeach kind of means show that they're a liar, and is usually a more unpleasant process. It's very hostile when you need to impeach somebody, as far as courtroom tactics go. And while not every victim um, is going to recant, many do, and we have to look at it and say, is if we do this impeachment, is it going to make it so she doesn't report again in the future? We have to take that into account. And if it potentially will, if we want to be able to leave that door open for them to either come back and refile, allow us to refile the charges, or if we think that it's serious enough that we'll proceed, or we have the way to proceed without them, then that's something that we will do. Um, the I think I saw something pop up here. Um, the question is, what about trauma-informed judges or judges knowing the new laws regarding DVSA strangulation that are in place? Unfortunately, I can't answer that question. There is, and I am so sorry. I know that probably Beatrice knows her name. I can't remember who does the trainings for the judges. Um,
Amy Hernandez?
yes, thank you. Amy Hernandez is really great, and she does what she can for sure. But sometimes it's up to the prosecutors to educate the judges on what the new laws are. And so that is part of our job. Yes, that the judges are the ones that make those decisions. Unfortunately, we there are good judges and bad judges everywhere. It really just depends. And unfortunately, we don't really have a way to switch a judge because they're not behaving in the right way. We just have to work with the judge that we have, unfortunately. And it really doesn't help to dismiss and then refile, because it will go back to the same judge usually, because it will prevent forum shopping or judge shopping, and they do not want to do that. So sorry that was not a great answer, Kimberly, but unfortunately there is no great answer for it from me. Maybe Amy can be somebody that can come in another time and talk about that. Um, but courtroom preparation especially is a longer process. Um, with victims we need to go through, and we try to approach it in a way where they understand what we're doing. We're going to go through and ask them the questions, or kind of re-interview them to see, to make sure that things either line up, or that um, if anything comes out that we're missing, then we definitely want to know. But also we have to prepare them for what defense will do. And defense, usually this is the victim or this is the person, the witness that they need to poke holes in their story. And so we have to prepare them for that too, because it is not always helpful to either a judge or a jury for somebody for the witness to be hostile to the defense attorney. And so we need to prepare them for what that is, and also educate them on proper behavior within the courtroom. We understand that this is still a traumatizing process and we can't control everything, but that's the big thing there, is just understanding appropriate demeanor and things like that. Most judges are not going to fault somebody for not wearing their Sunday best, if you will, to court. Jeans and t-shirt or whatever is usually okay as long as it is not revealing. Uh, that is usually the main thing that it just needs to be appropriate to for the court. Okay, so my even before I took this job as prosecutor, but even more lately, especially if you look at comments on any news article, um, everybody's favorite thing to comment is that don't give plea offers the to anybody, really. They want every case to go to trial. And unfortunately, that is not something that is a possibility. If we did that, I can tell you right now, my caseload in my courtroom, as just one attorney, there's four attorneys in my courtroom. I have 300 cases. And that is a lot. And my other attorneys, they have different caseloads, different types of crimes that they cover. So theirs are a little bit less, but they have anywhere from, 25 for the one that handles all the murders and more serious charges, and um, up to, that 300 mark that I have. And so it really just depends on the prosecutor. But also, trials will take a long time, and there is not very many trial settings. Most judges do one trial per month. And so, um, if you think about it with how many judges are in your courtroom, um, or in your county, that's not very many trials that can happen with how many people are charged, especially if each courtroom has around 500 cases per judge, at least in the criminal sense. They could have more even than that. But uh, it's just simply not possible to take every case to trial. And so we have to look at if we can get the same things accomplished out of a plea offer than we would at trial, then that is something that we will strongly look at. Um, and so and then also big part of it is the victim. Are they wanting to participate? Are they wanting to um, continue on? Are they wanting to wait that potential 2 years to get to a trial? Most don't realize that that is how long the process takes. And so I would encourage you, even as victim advocates, if you're talking and they're asking how long things are going to take, be very honest that going all the way to a trial can take multiple years. And the reason I say be very honest with it is because it will help, selfishly, it will help prosecutors manage those expectations to show because while both defendants and victims have rights to a speedy trial, it is very nuanced about what that means. And if a defendant is waiving their speedy trial rights, unfortunately, that will trump the victim's speedy trial rights. And so uh, there there really is not a whole lot that can be done if the defendant wants to or needs to delay the trial and the victim wants to move forward. Very, very rarely will a judge overrule that. And it would just depend on the reasons, obviously. Um, but we will go in and we'll talk and we'll look at different things and try to see the sentencing matrix or what would be a potential outcome anyway. Like I said, on somebody's first offer, even if it's a felony 3, they are likely not going to be going to jail or prison. And so there's often, well, we will offer a misdemeanor A or something in order to give them an incentive to not have a felony hanging over their head where they would potentially go to prison, but they would still have to do other things. And that's where these parts of the plea come in that I have here. So we have rehabilitation, restoration, punishment, and supervision. I thought I had seen a chat bubble pop up, but I don't know how to get it to pop back. I don't know where it went. So If there is a question, Beatrice, just interrupt me and ask the question, and I'm fine with that. Um,
There wasn't a question. Kimberly had just responded that that was a great answer and thank you.
okay, just good to know. Yeah, and if you guys have questions while things are going on, please either raise hands or type it in the chat. Okay, so for the rehabilitation portion of a plea deal, our goal is to correct the cause of the crime. So the big thing with that is going to be treatments. If it was drugs or alcohol, we want them to get a substance use evaluation and treatment. If it's mental health, where they have a mental health disorder or drug-induced mental health disorder, then we will have a mental health evaluation and treatment, or sometimes both. If they are having anger problems or things like that, anger management. Thinking errors is more of a they call it like a cognitive restructuring therapy where it's to try to educate and um, almost using therapy to change how their brain works and their impulses to commit crime. If it is due to different types of behaviors like domestic violence or sex abuse or batterer intervention, then there are those types of treatment as I don't know, is Ned still creating or is the state still creating that domestic violence modules now that are going to be used for all domestic violence treatments, where it's going to be more standard now, or has that been done yet, Beatrice? Do you know?
No, I'm not sure. I
Okay.
will follow up with that.
I know
But
it's
he says he doesn't
a
believe so.
okay. I know that it's part of state law that they're doing that. Maybe it's not Ned specifically doing it, but it's supposed to be part of state law that they are creating a more standard. Oh, Ned retired. That makes sense. Um, why he wouldn't be doing that. Um, so they there is somebody out there making a domestic violence um, standardization types of treatment, um, and so I'm guessing that will be soon because I think they had 3 years from the time it passed, and that would be next year, or maybe it's 2028. I can't remember. Um, but yes, that is the correct name, Vicky. Thank you. The Domestic Violence Treatment Board. They are the ones that are working on that. Um, and that's just because a lot of domestic violence was just being treated with anger management, and that is not what needs to happen. Anger management is more for assaults that are not domestic violence in nature, and so or other types of crimes. But it still can be helpful in domestic violence situations, but also a lot of domestic violence, even though it is charged as domestic violence, the current domestic violence therapies are not geared toward them. And so, what I mean by that is technically, and this seems very odd to say, but domestic violence in state code, if a parent abuses a child, it is not domestic violence. Um, Yes, I know that's weird. It is child abuse, and so it's different and it's treated differently, even though it is technically within the domestic setting. But also but domestic violence could be somebody living with a roommate or somebody with a grandparent to grandchild or other type of family or intrafamilial abuse. And most domestic violence treatments, at least in most counties, are focused on husband and wife or boyfriend, girlfriend, where they are intimate partners. And so there is not a lot of appropriate, or I wouldn't even say appropriate because it's still appropriate, but there's not a lot of treatments where it is related to the type of domestic violence it is, unless it is a husband wife or a a relationship that has that sexual component type of thing or relationship component, intimate relationship component. And so a domestic violence treatment may not be appropriate for some types of domestic violence, like grandparent on grandchild or roommates, because if they are not in an intimate relationship, then the treatments really do not apply. And so we have to look at different options for that. Also, vocational unemployment, many people commit crimes because they don't work or they are on the streets or they have low income. That is a very common thing. Yes, especially in domestic violence, it doesn't really have, anybody can commit domestic violence, but for the most part, most crime happens in lower socioeconomic situations. And so getting somebody the either education or training that they have in order to secure regular employment is very helpful. Um, Different types of courses, and then, of course, education is another part of rehabilitation. Um, all right, restoration, and this is mostly where the victims come in. Protective orders are a form of restoration, and that is mostly to make the victim whole again or the community whole again, in order to try to bring them back to the level that they were before. Obviously, that's not going to be possible because the crime has happened. You're never going to be the same again. But a protective order or a no trespassing order, if it's businesses or different things like that, can be very helpful. Restitution is another major component. I'm sure you guys have had trainings on restitution and what that is, from the restitution specialist there at UOVC. But there's also other types of restitution that UOVC does not pursue or collect, and so that is part of the prosecutor's job in order to get that. So things like where they were not able to work, the maximum amount of payouts is usually for about, I want to say it's 65% of 480 hours if my math is, or not math, but if my memory is correct. Um, the is what UOVC can pay out. And so there's still that 35% that UOVC did not pay out. And then there is anything after that 480 hours. And so the um the uh the big thing there is trying to get them to. Oh, why is this? I need to go back. There we go. Get those remaining hours. They will pay for up to 25 sessions of therapy, sometimes a little bit more. But the therapy past that, they will pay for funerals, but only up to, I think it's $11,000 now. I know it was 7,000 for so long, but I know it changed. But um, the 14,000. Um, Thank you, Vicky. You're on top of it. Um, and yeah, so we would, if the most funerals cost more than that still, unfortunately. And so trying to get that additional, or things that they won't cover, like property damage that would normally be covered from insurance, where there's deductibles and things like that. Not all property damage. I know there's some, but yes, I think somebody just posted, Beatrice just posted that. So I just encourage you to watch that. But there is codes about that and different parts of the restitution. So um, victim impact statements are the biggest way that victims have a say in this restoration. They are able to speak to the judge directly and state how the crime impacted them. And that could also potentially make it so a judge could um, decide to add different um, different things for sentencing. Those victim impact statements can be very powerful, because a judge uh, usually is not bound by the plea agreement sentencing recommendations. And we'll talk a little bit about that. And then community service can also be a big portion of it. If there is a crime where they're not going to go to prison or jail, and for me, at least as a prosecutor, I want them to do more than just, and there's no restitution, I want them to have some type of impact to their lives. So whether it is a fine or community service to help repair things, then that's something that can be done. Um, Types of punishment. Again, fines are a big portion, especially in the justice court. I apologize. My child just got home from gymnastics, so if you hear her, I'm gonna close my sound curtain real quick. Sorry. Okay, sorry if you hear her. Thursdays and Fridays are my work from home days, so I should have probably gotten a better one, but she might be yelling. So, anyway, fines are biggest way to punish, especially like I said, in justice courts. There are certain statutes that have mandatory minimum fines, and so DUIs are the main ones that have that, as well as some other things. But that's one way. Incarceration, meaning prison or jail. Oh, and going back to fines just a little bit more, most district courts are not going to impose a fine unless it is mandatory. And that is simply because the cost of the treatments and other things that they are going to have to pay for are either going to exceed that fine or they can't afford a fine anyways, especially if they are represented by a public defender. And then home confinement with ankle monitor or other things like that. So that potentially is different ways of the punishment. Then there's um, other alternatives, just depending on, especially in juvenile courts, they are all about alternative punishments and things like that. They're not bound by the same rules as adults would be as far as their punishments would go. All right, and then there's supervision. And supervision, I know it seems silly to say there's two types of supervision, supervised and unsupervised, but that is actually what it is. So we have supervised, which is probation, whether it is through your local county providing probation or adult probation and parole. Your local county is going to provide probation for misdemeanors, and adult probation and parole is going to provide the probation for felony level offenses. And the length of probation is dependent on the charge. So most misdemeanor A's, their maximum amount of supervision is 24 months. Felony threes are 36. I believe felony twos are 48, and these are all in months. And felony ones, I believe, are 60, but could be longer depending on the crime. And then there's also obviously different things depending on the crime because there could be registrations on different statewide or nationwide registries like sex abuse cases and things like that. The different types of probation, there's private and then government. Um, Private is usually only in, not usually, it is only for misdemeanors, at least in my county, in Salt Lake County. And I think across most of the state, most private probation providers cannot provide probation for felony level offenses. They will often include random UAs. All probation has a no drug or alcohol policies usually. How strictly that is enforced is dependent on what the original crime is. Um, but that is something to be considered. And then there could be potential punishments from the probation officer for violating that. It is not a throw them straight into jail because they drank or had illegal substances. They will require classes, other types of programming and therapy, and then depending on how serious the crime was or what their needs are, um, either weekly or monthly check-ins, sometimes quarterly. It really just depends. Unsupervised is just court probation or good behavior probation. Um, I do not like court probation because what it does, or good behavior probation, because it turns me into the probation agent. Most prosecutors do not like that. And that is because they are going to be the ones that have to see if somebody is committing new crimes, whether that needs to be, their probation needs to be violated. Most of the time, this happens on what's called a plea in abeyance. And I probably should have put that in with a plea in abeyance, but a plea in abeyance is simply somebody pleads, but the court holds it. And then after a certain amount of time, depending on what the agreement is, it could be dismissed completely or the crime could be lowered multiple levels. So if I had a felony 2 level charge that I'm putting on a plea in abeyance, I could lower it to a felony 3 or a misdemeanor A after completing the terms of probation successfully. And then it would enter that way. But there are also ones where a plea in abeyance would be dismissed completely. So, meaning the case would be dismissed and it enters as a not as if it never existed. The conviction never enters on some of these pleas and abeyances. So you just hopefully your prosecutor explains to the victims what that means and what those are for those, and also gets their approval. Um, Victim consultations obviously are the biggest part of forming our plea deals here. Um, in and I just put the little statute down there, but 7783, very bottom, last line, it says that, and I think actually since my screen is shared, I can just pull it up right there. Can you guys see this that I have here with the statute? Um, so just right here down at the bottom, number 15, um, if a case is going to resolve before trial, the prosecutor is going to notify of that possibility as soon as practical, and then try to talk to them about the details of the plea deal. And so I know that a lot of people worked really hard to get this number 15 added into law because it wasn't necessarily in there, because sometimes prosecutors were making offers or deals without talking to the victims at all. And so it is now a requirement, at least to inform them as soon as practical. Sometimes, unfortunately, things happen fast, and it may not happen until after the plea is entered, especially on some of these lower level crimes where they are often resolved in the very early appearances. Um, okay, let's go back to that. Okay. Um, Most prosecutors are going to try to seek input from the victims on what they see, or what they would want as a potential resolution. Um, it is not practical, again, to take every case to trial. It is not practical to expect the cases to all uh, res sorry, guys. Um, it is not, but because we have to manage those expectations and knowing um, the there we go. Sorry, just getting her to not yell on my door. So we have to be able to talk with the victims a little bit about what a realistic outcome will be, even if we were to be successful at trial, and what they are really seeking. For many people, depending on what it is, they want either a permanent protective order, or they want some type of treatment, or they want restitution. Those types of things are major parts of what we talk to them about and what is and isn't going to be able to be got within a plea deal. We also have to look at different things like we, unfortunately, and this is why if you have a victim that's having a hard time or they are wanting their own representation, that's why I would recommend contacting the Crime Victims Legal Clinic, or if it's a murder, Utah Homicide Survivors, on that. But the prosecutors represent the state. They don't represent the victim. We are going to do our very best to do whatever we can to get the victim's wishes followed, but sometimes it is just not reasonable for us to take, and we have to look at that from ethics of uh, our requirements, our office that we have as a prosecutor that represents the state, to see. And so that's kind of what I wanted to talk about. Have any of you, and again, either unmute or chat, But has anybody ever had a victim that was angry about a plea deal and they did not want that plea deal to go through? I know Beatrice definitely has. Um, but if if you have, I want you to unmute yourself and talk about it a little bit while I sneak a drink of my water.
So we had a case, it's been quite a few years, but we had a case, it was a hit and run. It was a DUI, but because the guy took off, law enforcement couldn't find him right away. There was a lot of, there was just a lot of, I don't want to say contention, I don't know what the right word is, miscommunication and cooperation between the victim's mom, because the victim was a minor, and the prosecutor. And she ended up writing like a 8-page victim impact statement. She was not in agreement with the plea deal when it went before the judge when we were moving forward with sentencing. The prosecutor turned around and looked at her when we were in court and said the victim's mom is in agreement with it and under pressure. It was clearly under pressure. She just nodded her head and let him move forward with it. It was just a really heartbreaking case in every direction. But that one was really hard because I really at that point didn't even know what to do to help other than here's treatment, here's this, here's that. But she definitely did not want to move forward the way that the prosecutor did. But I also understand what the prosecutor did from his side.
Yeah, and that's um unfortunate and you know that is something that a prosecutor probably should have allowed her to speak her mind and be more truthful about. Um, for me at least, I've had it where victims are not in agreement with how the plea deal is, and from my perspective, I will let the courts know. Because that is something that they always ask, is the victim in agreement with this? And usually it is a yes. Sometimes they're still not happy about it, but they understand and they're in agreement just because they know that what their expectations are were not realistic, but sometimes they're upset legitimately and they don't agree. And so it can make a difference with victims saying that, and no prosecutor, no reasonable prosecutor, I should say, should be offended if their victim or if the victim of the crime does not agree with the plea offer, um, because that is not our job with that. If they want to oppose it, then they can say that and they can speak that to the judge. And sometimes it does make a difference. If they have already entered the guilty plea, it is uh, potentially um, something that, well, it just depends. The judge could, depending on what is said, and I have seen this, force a case to go to trial. They could undo the guilty plea. They could not accept the guilty plea or the plea offer that the prosecutors have presented. And so I have seen that happen. Or it could potentially change the type of sentence that it pronounces. And so a sentencing condition is not a good reason to withdraw a guilty plea. And so that is often something that sometimes the courts will use to try to get something additional for the victims. I have seen that where um, I have a case just recently where a defendant wanted out after committing some assault and he entered his guilty plea. I opposed his release and wanted him to remain incarcerated, and the judge agreed with me. And then, because the judge agreed with me, he tried to withdraw his guilty plea, and that is a sentencing condition, and the judge did not allow him to withdraw his guilty plea. And so sometimes those victim impact statements can make a big difference in, especially um, with what the judge will give as additional consequences. Um, yes, it is important with what Kristen said, it is important for the judge to ask the victim if if the victim agrees on the retail. I believe it is a statutory requirement. I have never had a judge not ask me that. Even if it's not statutory, it is definitely followed on whether it is agreed to or not. Not all victims can be at the sentencings or at the entries of plea, and so the prosecutor will usually represent whether they agree with it or not. All right, sentencing recommendations. Um, Now, sentencing can happen anytime between 2 and 45 days. But in a lot of crimes, it is waived, especially if they want to proceed off of a plea deal. They will waive the time for sentencing and go through with the sentencing right there as they've entered the plea deal. When they do that, that makes it so that they are not able to withdraw their plea. They have 30 days to withdraw their plea, and if they want to be sentenced, then they waive the ability to withdraw their guilty plea. Um, if it is a pre-sentence investigation that is needed, or a pre-sentence report, then those will usually take about 45 days. And those can be something that are more in-depth. Now, I wish that I would have been able to find a fake pre-sentence report. But unfortunately, I only have real ones, and if I redact it, it's not helpful. But there is a couple different things um, or tools that you can use. And kind of going back to my internet screening here, right here, the adult sentencing guidelines e-forms on the Commission on Criminal and Juvenile Justice. This has that sentencing matrix. And so you can put in somebody's prior crimes and other things, and it will show what their matrix is. There will be certain things here. And so just to kind of put in an example, if they've had prior felony convictions, let's say they've had two prior convictions of a felony, they've had some misdemeanor A offenses, and they've had 3 to 5 of those. They've had one juvenile conviction. I'm just making these up. And their longest, most recent, or not longest, but their most recent crime-free gap, it was only 2 years, so it would not apply to that. They've had a uh, prior revocation um, of their probation before. We're gonna put this in here, John Doe, most serious, and it will go in. And we'll say it's 60 months, I think I don't know if that's years or not. So we'll say that that's a third degree against a person. There's a third that's an other, and that one was 1 year, and we'll just go there. Um, and then this is what will kind of pop up. So it gives them this kind of matrix here on what it is. And so this is the end of the report. The full report will go into the crime, what happened, what the defendant says about it, what the victims say about it, if there's restitution, where the person has lived in their past, any adverse history that they may have, any things that would be potentially mitigating, like maybe they were abused as a child, or they had, or they were homeless, or things like that. And they look at that and they go, okay, here we go. So the uh, goes through all of that as well. But this little matrix kind of gives the judges what they should be looking for. So in this fake scenario, this person scored an 11, which would be in this third row here. And depending on the type of crime it is that is currently being charged, I did not put that in, I should have, it will give us a amount of months that they should spend in either prison or jail. So if it was a third um, degree felony or a class A misdemeanor, then they're going to be on presumptive probation. Um, but if it is a either a second degree or a third degree of another type of crime, they could potentially do some jail as a condition of probation. And most of the time, that's going to be at the midpoint. And a lot of people will get very angry at some of these types of things. And I do see a hand up. Let me just finish this really quick and then I'll have you speak there. But um, the if they serve this maximum amount of sentence that the crime has. So let's say it's a third degree felony, 0 to 5 years. If they serve 5 years, then once they are out of jail or prison, in that case, if it's the 5 years, they will just be released. They will have no supervision. They will have no accountability. And so that is why it is important to have these types of things because it will also give a adult probation and parole or Salt Lake County the types of supervision or classes or things that they need to do while in jail and also outside of it once they are released. Um, all right, Corinna, I hope I'm saying your name right.
Hi, yeah, sorry. So quick question. So this matrix only takes into account the convictions, right? Not what people
Correct.
have pled down from. So like,
Correct.
because I find a lot where, I mean, for example, I've got a case that we're going to trial today at 12:30. Um, and we have multiple different DV charges, but he's just pleading to DV assault and we're dropping the rest of the other charges.
Yes.
So, okay.
And that is looked at as part of the sentence. Like they'll look at that and they'll say like this is the offer that is being given. They're dismissing these. This is everything that happened, and that's where part of it goes. But yes, that's unfortunately a big part
So
that
in the matrix, though, it wouldn't take into account that this person really has had a lot more offenses than what they've been convicted of
yep,
per se.
unfortunately.
Okay. Okay. Thank you.
Yep. There are certain things that could uh put them at a higher thing due to either prior convictions of any types or different amount of charges. There is both a habitual violent offender and habitual offender, which can increase this matrix in different ways. And that just depends on how many times they've been charged in the last 3 to 5 years, depending on different things. So, somebody that is a habitual offender has 19 charges in 3 years, whether they're adjudicated or not, whether they've pled or anything like that, um, is different, but it's 19 separate cases. So if they've had a lot of different cases, then that's a potential that would trigger some other certain types of things. But yeah, unfortunately, the Matrix is not going to look at the dismissed charges as convictions because they're not convictions. They were dismissed. And so we just have to, that is part of the plea negotiations and the understanding. One thing to realize down here, if you have multiple types of crimes that are being pled to, consecutive and concurrent is something that often people don't understand. And so if you have a consecutive sentence, 40% is added. So let's say you have um, the biggest charge is 15 years to life. And then you have another charge that was 5 to 15, and another charge that was 0 to 5. And the prosecutors can ask for concurrent or consecutive. And what that really means is, this is where the judges have some leeway because the statute is what the statute is. The judges have to pronounce the indeterminate sentencing, which I think I saw that you guys have had the adult probation and parole already come and present, and they're the ones that really decide the length of the prison term. But judges get to decide consecutive or concurrent, and that 40% is added of the lower charges to the longer one. So if it is a 1 year, 40% of 1 year is roughly 4.8 months ish. My math might be wrong on that, but it's close. So 5 months would be added to the longer sentence. So it'd be 15 years and 5 months rather than 16 years, if that makes sense. Or if it is concurrent, then it just adds 10%. So in that case, it would have been 15 years and 1.2 months. And so basically, just keep that in mind with consecutive and current. Obviously, consecutive will give us the longest amount of time of incarceration, and the board is really who decides how long they're going to serve of each of those, because many crimes are 0 to 5 or 1 to 15, and they're the ones that decide how long of those that they serve. Let's see, go back here. I think I had. Oh yeah, that's the same one. It's just a blank one. But they have all sorts of different ones. They have a homicide. They have DUI homicides. They have sex offense ones. So play around with it and kind of see if you are able to get your defendant's prior things. Like I do this sometimes with cases that are a little more complicated, where I want to see what it would possibly pop out at because, and I will show this to the victim sometimes too. And I will say, look, this is what it is coming out as. So for instance, if it was a crime down here, if it was in like in that third possession or a class A, so let's say it was a class A domestic violence, I would say, look, the the presumptive probation is the charge here. The judge is more likely than not going to put them on probation and they will not have any jail time. And just trying to give them that realistic understanding of how that works. But yeah, it's a good resource. Again, after a plea is entered, we could have different versions of what those sentencings will be. Joint recommendation from the defense and prosecutors hold the most weight, but we could also argue sentencing. I've had it both ways all the time. Doesn't really matter. It depends on what they're wanting. So, in that case where I described earlier, somebody who had committed a couple of different assaults, I was arguing and wanting him to stay in custody while he got a pre-sentence evaluation and also be able to go and make that recommendation to prison. And the defense is arguing for release and probation. We don't have to agree on the sentencing to have the plea be entered. Sometimes we will agree just to argue the sentencing, but most of the time it is going to be joint, and those hold the most weight. Plea in abeyance, I mentioned those before, where the court holds the guilty plea and they don't enter it for a certain amount of time. One thing to know with a plea in abeyance, all the agreements need to be included in that plea in abeyance document, and that includes restitution. If restitution is not mentioned in the plea in abeyance agreement, defense can make the argument that it is effectively waived and no restitution is sought. So plea in abeyances must contain the restitution amounts before they are entered in order to ensure the restitution happens. And that is because plea in abeyances are, again, everything that is within the document. It is an agreement between the prosecutor and defense, and the judge does not get to change the terms of the plea in abeyance. There's also this thing called a Rule 11, where the judge will bind themselves to the sentencing recommendations of the prosecutor and defense, their joint recommendation, regardless of what the pre-sentence report comes out to. And sometimes this is done in cases where different ones, but basically where the sentence has already been figured out, and in order to avoid either a trial, the prosecutors will agree to some type of release or treatment or something, and the judge will bind themselves to it. They do not have to, but if we ask them to and they choose to, if a pre-sentence report comes back and says, hey, we are wanting them to go to prison, the judge will have to usually say no, and that they are going to not follow those recommendations. Victim, again, doesn't have to agree. The judge doesn't have to agree. So after they enter their plea, we will, again, make a joint recommendation or argue the sentencing, and the victim will be able to come up and give their victim impact statement and say that they don't agree, or potentially if the judge hears what the potential joint recommendation for sentencing is, they could say, I am not going to do that. I'm going to recommend something else. So sometimes I've had it where and it, even in a joint recommendation, we have said, oh, we want this person to be on probation. The judge says, nope, I'm not doing that. He's going to jail or he's going to prison. And that is another portion where victim impact statements can have a lot of weight, is to um, try to change the judge's mind or to not follow the joint recommendation of those. Um, After the judge gives sentence, then that supervision portion kind of comes into effect. Probation, or they're going to jail, um, or prison. The probation, again, who it's supervised by, they usually have to report within 48 hours, sometimes 72, depending on who they're reporting to. If it's jail or prison, they will sometimes be given credit for time served. And what that means is that they've been incarcerated at some point within the process, whether it was a couple days only or many days. They will say, because the maximum amount of time, they need to give them that credit, so that way if they do get sent back to jail for violation of probation or prison for violation of probation, then those days are counted for them on that. And the maximum amount of time that they can spend is dependent on that level of offense. So misdemeanor A's, or misdemeanor B's, with 180 for misdemeanor B, up to 1 year for misdemeanor A, and then 0 to 5 for most felony 3s, 1 to 15 for most felony 2s, 15 to life for most felony 1s. They are needing to track that amount of time so that way they don't serve more than the maximum amount of time that is given. And then prison, I'm not going to go over the Board of Pardons and Parole because you guys already had a great presentation on that, I'm sure. They are the ones that really determine the full amount or the full length of the sentence. They also will have supervision over somebody. If you don't know, I'm sure they showed you, but a really great website to see if somebody is going to be getting out anytime is boardofpardons.utah.gov or bop.utah.gov. You can put in somebody's name and then it will search, and because I did not prosecute this person, I'm going to type in somebody's name here, and I will show you what that is. All right, so if you go down here, it will show all of their supervision that they've had before, including up until before that other time. So this one right down here, 2022, that's when he was officially had his first hearing with the Board of Pardons, and they officially decided the life without parole. But other times it's going to say scheduled for a hearing, like this down here. So he had other crimes. He scheduled it for a hearing. You can see what the results of that hearing are and that they are going to be either released on parole or whatever. But it will also show a different type of matrix for how long that they have up until you can see the expiration for these crimes are, 20 or not, I don't even know how to 2300. I don't even know how we're going to say that when it gets down to it. But 2318 is when the maximum amount of time that if he lives that long, then he'll get out or not be under their supervision. Obviously, that's not going to happen, but these often will look like this. And so we just have to, that's somewhere where you can look. If somebody commits a new crime while they're on parole, this will often show different hearings that are coming up, and potentially do different things there, and that most of the time the parole board is waiting for the new case to be adjudicated or for a conviction to enter before they decide when their next potential release date is. So this is always just a good way to kind of see when somebody could possibly be released after their prison. So once somebody is convicted, I would encourage you to give your victims this website. But I think it's about I want to say it's 60 to 90 days. And again, the Board of Pardons probably covered it. But you can type in that person's thing and it will show right here when the next hearing will be on this upcoming hearing date, or when the initial hearing or things like that would be. So kind of a cool tool to use on that. All right. Yeah, we have time. All right. For victim impact statements, many victims, and I'm not trying to put them down on this, but many victims will look at victim impact statements as a way to confront the defendant. And that is not what a victim impact statement is for. And in fact, could be something that would make it so they are not able to read their statement um, at during that time. The judges can cut them off if they feel that they are not um, following the guidelines for victim impact statements. So what the victim impact statement is looking for is the emotional impact, how it has affected them, physical impact if they have physical injuries, if they have financial losses, the long-term consequences of the crime that occurred. That is what the judges are looking for. And you are addressing the judge in the victim impact statement. And so, yes, often they're not going to, um, throw anybody out for the most part on if they decide to address the defendant. But I would encourage them to address it in a way that it is technically addressing the judge, but is still being said to be heard by the defendant. So rather than turning to the defendant and saying, "You are a monster," um, you tell the judge, "He is a monster." And so that is kind of the way to do that. And you want to be able to try to help. I'm sure all of you have helped with victim impact statements in one way or another. And some judges care more than others on whether people can or can't address the defendant, but technically, again, it is to address the judge. And so for me, at least, our office, we have victim advocates in every courtroom, but not every crime has a victim advocate assigned. And so, for instance, my assaults that I have, they're lower level, they're not domestic violence, and so I effectively become their victim advocate a little bit within that realm. And so I'm going through and helping these people write their victim statement on how this has affected them. And they talk about how they're scared to go out at night because he lives right next door to them. They are scared to leave their house because they're worried that he's going to be waiting for them or run out of his house. They're scared to go grocery shopping because they're scared to run into him, things like that. And then, if they've had physical damages where they, oh, I had to get surgery on my mouth due to the crime, or I was in a cast, or different things like that. And then, oh, I had to put up security cameras, or I had to miss work, or I lost my job due to the trauma that this caused. That's something that the judges want to hear, as well as the long-term consequences. So those are the big things to address on that. And if you're, as a victim advocate, wanting to prepare them effectively with it, just let them know, like, hey, this is the time to let the judge know how you feel about it. Also, it's where they should say, I don't agree with this punishment. I don't agree with this plea deal. Different things like that. That is completely appropriate. And you are able to say that. And they are able to say that. And I would encourage them to if they do not agree. Again, no reasonable prosecutor should be offended if a victim does not agree. We have a unique insight into the courts and how they work and how pre-sentence reports work, and whether or not it is a reasonable offer and outcome, whereas not every victim understands the nuances within the criminal justice system. Again, in the sentencing hearing, you're going to have state's recommendation, defense is going to argue and make their recommendation, the victim's statement, and then the judge will pronounce their statement or their sentencing, and they have that discretion to change any types of recommendation or potentially reject pleas due to what has been said or what the type of crime is. Um, the biggest thing that I can say is it is a lot more effective to the judges if you can articulate why to do this sentence or not to do this sentence and what you would like to see instead or your victim would like to see instead. So just rather than say, I don't agree with this, some type of concrete resolution or something different that they would do as part of the sentence is what I would recommend that they write. If they say, I don't agree with removing these 3 charges, these are the ones that are most important to me. I don't think that, that is something concrete. But if it is, I just don't like it. I want him to go to jail I want him to go to jail. That whilst it sounds um, direct and is an actual thing, they should articulate why they want that type of punishment. And so that will be helpful in those victim impact statements as well. So I know I said I was going to go till 12, so hopefully I can just get you guys to start asking questions because we went faster than I anticipated there. But anyway, so for the prosecutors at least, we are trying to balance accountability, public safety, rights of the defendant, and then the voice of the victim, yes. But also we have so many things that we have to consider within our pleas offers that and we'll have certain guidelines within our own offices as well on what we can and can't offer. And so we just have to be prepared for all of those things as these come up. And we know that it is very frustrating for the amount of time that these cases take, and that not everybody's going to be satisfied. But if you are having trouble or if your victim is having trouble, set up a meeting with the prosecutor to allow them to explain why they're doing certain things. Again, no reasonable prosecutor should be upset about wanting to meet with a victim. Yes, they're busy, but there's ways to make time to visit and talk with them about why they are offering certain things or why they are not pursuing certain things. A big part of, unfortunately, my job is when I have to dismiss a case because it is not something that I can proceed on, either ethically or due to evidentiary issues or witness issues or other things. And so we have to be able to go to the victims and tell them that. And that is not fun to do, especially because is it is our discretion, but we also have to look at what our reputation will be with the judge on or defense attorneys on pursuing these types of cases. To kind of give an example of one, this is not a victim crime necessarily, but just to off the top of my head, a DUI driver who hit, I guess there technically was a crime. She hit a parked car and then ran into a house. Now, uh, they did not perform any breathalyzer. The police did not perform a breathalyzer. They did not do any of the field sobriety tests. They were not able to get blood. So they had the person do a urine test, and urine is not an effective way of determining a DUI. So the defendant said, I was trying to get something fell. I was trying to get that, and that is why I ran into the car and then into the house. Um, and we had a urine test that said, yes, she had these uh, in her system at one point, but urine is not a way to determine whether somebody has it in their system right then because it has already gone through and processed in the body. And so urine DUIs are very, very difficult to do. And unfortunately, I had to, the DUI portion was dismissed and said that it was, reckless driving, and they still had to pay some restitution. So it was still worked out, but they were not going to get substance abuse evaluation and treatment for their alcohol use, or they were not going to get um, uh, mandatory jail that they would normally get within a DUI case. And so, unfortunately, that is just something that has to happen. And they were very upset with me when I told them that. Um, but unfortunately, that's something that sometimes we have to do. And you'll even see it in other types of cases. I think recently made waves down in Washington County. I don't know who in here is from down there, where that rape trial or rape case against that BYU football player was dismissed. Everybody was really upset. And in reality, what was happening is that they just weren't able to proceed with the trial at that point, and the defense was trying to force the trial. And so they dismissed, and then they either already did or are going to refile the case. That is something that also will happen. Unfortunately, it restarts the clock on almost everything, but that is something that I have had to do in cases where I have had to dismiss and refile, or I've dismissed a case because the victim didn't show up to trial or to the preliminary hearing, and then they approach us later, I forgot, or I didn't want to proceed, but now I do, and we will refile the case. So that is something to remember. Obviously, statute of limitations will apply in certain aspects of it, but just be aware of that. All right. Well, I don't have more, but I would love to answer uh, questions that you have. Again, as from my experience, at least as a prosecutor, I'm not necessarily representing the district attorney's office with that. Um, but at least from my experience as a prosecutor and with prosecutors, I worked side by side with prosecutors on with victims before I took on this role as well. So any questions? I'm sorry I did not fulfill my full 2 hours. If not, I know that I was told to do that. So we can just sit here for 26 minutes to get your full 2 hours if we need to.
I don't think anyone will have any issue starting their lunch a little bit earlier today.
Well, it went past the 30-minute mark, so I feel like you can still count that full extra half hour there, I
There we
think.
go. Yes.
Yeah. And there's links to click on and some homework to watch that are in the chat. So that'll be some self-study 30-minute CEU.
I love it. And I don't want to cut anyone off. If there are any questions, or go ahead and unmute, use the chat, whatever you are most comfortable about. Oh, Karina is asking who all attended the MDTs.
Are you talking about the multidisciplinary teams? Okay. So yes, multidisciplinary teams are usually prosecutor, a victim advocate from within the office, a detective, and sometimes a social worker or others. And so, but it's multiple prosecutors, subject matter experts, and things like that who are more experienced with those types of crimes are the main ones. And so they're the ones that kind of come up with these plans for the prosecution or for the types of charges. It really just depends on what the charge is, who would all be coming to that. But usually it does include the prosecutor, victim advocate from the office or otherwise. That is a social worker, and then detective as well as the subject matter experts for those types of crime.
Is it the victim advocate from the county attorney's office or from
Usually the county
Okay.
attorney's office.
Okay.
Sometimes the others, it could include the interviewers from like the CJC. If it's a child sex crime, it could have those. Or yeah, but mostly it's going to be or our investigators from because our office, I should say most, all prosecutors' offices have their own investigators too that are usually like semi-retired law enforcement, and so they will also attend depending on what it is. But yeah, usually it's kind of the staff from within the office, at least in our office.
Thank you.
Yep, and then Vicky answered a question as well that sometimes the detectives will ask. But yes, yeah, especially if you have extra information that you can add that's not necessarily in the police report, that is something really good to do.
Something that helped us out when we weren't able to attend all the MDTs because it would conflict with our schedule or it was scheduled a little last minute. We would give information to our detective just to let them know, similar to if you've spoken to a prosecutor, like here's what the victim is going through and what they'd like to see. We talk to the detective and just let them know here's where they're at right now, how they're, if there is any additional insight. Sometimes we'd be able to attend with them as well too. As the Salt Lake District Attorney's Office was nice to invite us to those. But if it does conflict, I think it's really helpful to just create those relationships with your investigators and prosecutors similarly, where they know that as an advocate, they can turn to you. Ryan would call us the crystal ball of what's going on with the victim in the case.
Yeah. Especially for those of your victim advocates that are, I mean, and this is not necessarily this is just going off of um, what Beatrice said about the victim advocates for meeting the prosecutors and things like that. So not necessarily multidisciplinary team because it would be a lower level offense. But for those that are in where their cities or towns are in the county justice courts, they often don't have a victim advocate assigned at all within the county justice courts for from the prosecutor's office. So reaching out to the prosecutor for that county justice case is also super helpful. Or if you're in Salt Lake City, the Salt Lake City uh, prosecutor as well. But or your city prosecutor, just reaching out and letting them know that you're there to help or assist or give information and pass that on. That's very helpful because I was always appreciative of that, and am always appreciative of that, I should say. But any other questions?
Brandon, I don't have a question for you, just a comment.
Okay.
I have been so grateful for the work you've done with homicide survivors. We've worked together, unfortunately, in the past. You've been absolutely fantastic. I love your level of compassion with which you function, I would imagine, on a daily basis. And I just want to give you a big thumbs up. You're amazing. And the state of Utah just is really blessed having you here.
Well, thank you. I don't like compliments, but thank you very much. That is very appreciated. So
If you aren't familiar, I'm going to throw in the link in the chat as well too, in case you're interested in looking into that or putting it to your
it
case.
needs very much updated. Since I have left, I have not updated the website. I'm still on the board, but I am not involved in the day-to-day. I'm not super busy, as you could probably hear from my 300 cases that I said I had. So I just am too lazy to change the website. But no, I definitely need to make some time for it. Yeah, Brock Best, who is listed on there, is the director there. And there's another attorney there, Aubrey, and they are still up and running and doing really great work. So reach out on all your homicides to them. If I can give a shout out to them because they are uh, doing a lot of good work that not a lot of people realize that are needed on every homicide. But yeah.
So they're so helpful. So thanks, Kristen, for that. And then I will throw in, since we mentioned the Utah Crime Victims Legal Clinic,
Yes.
their website as well too. You can always contact Bonnie Stone. That's their victim advocate. Usually, if you reach out to their main line, you will have to leave a voicemail, and then they'll get back to you, just so you know a little bit about the process. Unless things have changed since I left, it has been 2 years. But please know that Lonnie Stone's happy to work with you as well too, and at the legal clinic in general. But otherwise, just as a reminder, When you get off of this link, there should be a link to the survey. We would just love to hear from you so that way we know how we can continue to improve Swavo and make it, tailorize it for you and your needs individually as an advocate. So if you have any feedback or topics you'd like to see, please let us know. And also put the link in the chat. But otherwise, Brandon, thank you so much. I've worked in the field, but this was just one of the best recaps I've had, and just you gave so much more additional insight that I wish I would have had as well too as an advocate. So thank you so much for covering this pretty extensive topics. You covered all the things. So thank you so much.
Yeah. Sorry it wasn't a very exciting presentation. I know that PowerPoints are supposed to be more fun, but um, I I'm much better in person. You know this, Beatrice. I'm much more exciting, and so does Vicky. I have props and I yell and I do more fun things, but I'm this is better for getting more people to hear, so I'm okay with it too. But yeah.
Yeah. No, thank you so much, Brandon. And I think it's just you explain things in such a way that you're able to easier, I think, understand, and also understand that perspective that you're coming from as the prosecutor. So thank you so much. The other plug I was going to do is if you are interested in helping us plan future Swavos, we do have some openings for our Swavo steering committee. I know Kristen just joined us and is going to start helping us on our steering committee, but we'd love to have anyone additional if they'd like to join the Swavo steering committee. We meet quarterly to plan each Swavo. You can reach out to Beatrice or I will put my email in the chat. But yes, thank you so much, Brandon. I know that you're saying it's boring, but to me, I love just kind of hearing where you gave case examples and just really explained it thoroughly. We just really appreciate your time.
Of course.
And we will stay on for a moment if there is some question you had directly for us.